organizations have put forward that sometimes while you need to operate with phased implementation, you need to have a holistic review so that we know where we're going and what the consensus is. I will quickly say that consensus ought not to be between two political parties only. Consensus must be based on an informed citizenry where we all have a voice in what is happening. We are aware of the dangers of certain proposals that can be put forward, and therefore we can be vigilant when we hear recommendations coming forward that we're not in agreement with. So I am really urging us to really get a sense of what the phased implementation look like. We'll be asking our panelists at some point to just give a little historical overview of what has happened in the past. You know, that I won't preempt them a little bit, but I will ask Prof. Monroe in particular to speak to the process of what happened in the 1960s, that it's time for change in terms of what was then to what we need to do now. In the 1960s, it was what, 30 days for the public to make their views known. And even though the 30 days was there wasn't really an opportunity to really dive through because it was only 4 weeks that between draft and final constitution was done. And we're saying that in 2024, we're going to have to be revisiting what the process of consensus making really looks like and what public education ought to be. All right, so before we get to our panelists, however, we're happy to announce that we have a youngster among us. His name is Mr. Iwan Tingle. He's a fourth form student here at Jamaica College, and he's just going to be sharing some brief words with the audience. And I tell you, when young people talk constitution reform, I personally get excited because, again, it's not an abstract thing we're talking about here. It's understanding the powers of the government, the structure of the state, our foundational rights and freedoms as we have it. So, Mr. Tingle, where are you to tingle us with your words? So clearly moderating is not my day job, right? And after he speaks, we should be hearing from Councillor Michelle Thomas very briefly. And local government was last entrenched in 2015, so I'll be sharing some tidbits as we go along. Mr. Tingle?
Good evening, everyone. Picture Jamaica's vibrant culture and rich history evolving under the framework of a republic. Can you imagine the outcome, whether good or bad, due to the potential shifts in governance, identity, and global influence of our country? A republic is a form of government where power comes from elected individuals or citizens of a country, rather than a monarch. Jamaica's constitutional monarchy system traces back to its British colonial history, which began some 500 years ago. Since gaining independence in 1962, the British monarchy has been the sovereign represented locally by a series of appointed governor-generals. Our move towards a republic will undoubtedly cause certain instabilities during the period of transition. This is why meetings like these to inform the citizens are very important. If done successfully, it may allow the country to fully assert its own sovereignty with either an elected or a ceremonial president as our head of state. Can you envision having total control over our own affairs? It is time for our country to level up. Constitutional changes made by the new Republic of Jamaica will be felt globally. People and governments will either admire or criticize us. I believe initially we will be most vulnerable while dealing with the external and internal opinions about how the country should be structured. Worse to come, even supporters or allies may or may not betray Jamaica. You never know who's your friend and who's your real enemy. We must proceed with wisdom and caution. Sometimes Jamaica's vision of being a republic sounds almost like a fairy tale. This country has always been dependent on others to survive. If Jamaica becomes a republic, who's to say whether the countries that it has always depended on will not see an opportunity to take advantage? This is the nature of politics, I suppose. In a situation like that, what will Jamaica do? We should gather our best minds to the task, then the vision would be reachable. But what does Jamaica have now to support its bold claim of wanting to become a republic? What gives us the confidence to suggest that we will be better off after taking this giant step away from our colonizer? From Bogle to Bedward, Bustamante to Bolt, we Jamaicans have never met a challenge we couldn't face. Jamaica must be prepared for the consequences and benefits of this audacious move. Please allow me to use a web novel analogy for fellow students to understand the road ahead of us. This is Jamaica's story, being a cannon fodder trying to rise above the main character, the British monarch and its allies. We have to go into team player mode. As we continue to learn about this pending constitutional reform here and in our social studies class, I am very grateful for the opportunity to share my thoughts and the inclusion of us teenagers into this space. If this drive to the Republic is successful, my generation will be at the forefront of the new Republic of Jamaica and everything that will come with it. Thank you. I am Yuan Single, fourth form student, Jamaica College.
All right, another round of applause for the young man. He wrote that piece for his social studies class. So I think we must also say big up to the social studies teacher for ensuring that the class is current on the affairs of the country. Because if you're like some of us, we want to see the end of the monarchy, where we say the republic is the people's, the power of the parliament and so on is really for the people. Anything that the parliament does, it ought to be vested in the authority of the people, right? No, I'm not sure if Miss Michelle Thomas is here as yet. Is she? All right, so let's move on quickly. I will be brief, but I just wanted to share some of JFJ's perspective with you on the constitutional reform process before we get to our panelists. Now, you have some booklets here, and we will make them available online, and for those who want the printed versions, you can get them at our office. The constitutional reform process for Jamaicans for Justice, firstly, we want to ensure that there is adequate public education, which is why we're here today. We want to ensure that the constitutional reform process is owned by the people of Jamaica. And though you have a reform committee, they ought to be acting based on the views of the public, and that is something that JFJ and other NGOs, National Integrity Action, Jamaica Accountability Meter Portal, and others have been championing. The specific areas that JFJ has a vested interest in and our advocacy will be grounded in, some of which, if you've read the Constitutional Reform Committee's first phase report, you would note some of these recommendations. For example, you would recognize that the Electoral Commission of Jamaica, they have reiterated what was in the 1990s, that the ECJ ought to be entrenched in the Constitution. For those who are not aware, entrenchment really means that this particular provision has greater protection. And the only way to change it is by way of 2/3 majority in both houses of parliament. And you have to be doing some mathematics here. 2/3 majority means that at least 42 of 63 members in the lower house would approve, then 14 of 21 in the upper house would also approve. All right? So it's a little bit of a safeguard so that a single political party does not just usher things through the House based on their majority, which by design of our parliamentary system would be possible for certain provisions. And you would recognize that in speaking, I said the ECJ without the political ombudsman power. And if you were paying keen attention to the news cycle, you would recognize that that was one issue, that JFJ and others have been saying, no, you should not be subsuming the powers of the political ombudsman in the ECJ. And we're happy that the Constitutional Reform Committee has made that agreement. They have also made a suggestion that the public defender's body ought to also be entrenched in the Constitution. And just by way of knowledge, the public defender is there to ensure that they investigate any complaints of human rights violation that has been made against any citizen of Jamaica. But for JFJ, the public defender, my apologies, ought to be broadened in scope, strengthened into becoming what we call the National Human Rights Institute. And we're going to be talking about that a little bit more. Because though the public defender is there in law, and it's a good body, we want to ensure that it has good powers to investigate whatever human rights violations that have been levied against you. We want to ensure that the public defender can put forward certain recommendations to Parliament in a better way than what exists now, if it is that it is expanded into becoming, and I want to learn this terminology for short, the NHRI. Do not leave here today, you don't know what NHRI means, the National Human Rights Institute, and it's here in the booklet that you have. JFJ, for us, as a start, and I will be very brief in this because I need to move to our speakers, we advocate for a non-executive president. And I know many of you listening in and say, why JFJ want that? Because you hear about executive president and you think the United States model because that's what we're most familiar with. But we caution against going to a new model that in some instances they have gaps that are maybe a little bit far worse than what we have in Jamaica. And I want you to pay attention to what is happening with President Trump and so on. So we're saying fix our system here in Jamaica, have a non-executive president. But the non-executive president for JFJ is not ceremonial where you go about and just cut some ribbons and so on. I want you to think about what types of powers the non-executive president would have. So, for example, recently we heard about the government going to Parliament, and in a matter of 3 hours, you saw wherein the tenure of the Director of Public Prosecution, it also had implications for the Auditor General, but it was more so important because the DPP had already gotten an extension before, and no more was allowed by the Constitution. And the government went to Parliament in 3 hours. They moved the age of retirement from 60 years to 65. Why am I mentioning that? Had we a non-executive president with the powers that JFJ is recommending, the non-executive president could, like what happens in other jurisdictions, for example, Ireland, say, you know what? Before I put my signature on this bill to become law, let me make reference to the Supreme Court to tell me if this is in keeping with the Constitution. That is the type of powers I'm talking about now. Not walking around and cutting ribbons, but powers that would be there to offer checks and balances to the government. Our version of a non-executive president here at JFJ could also say, before I sign off on a law, maybe I would suggest to the House of Representatives to reconsider a provision that I have concern about. No president should be a rubber stamp for any political party. And we're adamant on that as we make our recommendations to the government on what the reserved powers ought to be. So these are the things I want us to be thinking about critically as we have a conversation. I don't want to go too much because the panelists are here And we have to ensure that we break down the topics so it to make sense. Because I don't want anybody to leave here and they say, but what then did say again? What does that mean? Please feel free to ask the questions. In the booklet that you have, and I keep putting it up, when you go through, you would recognize that for every single recommendation, there are some guiding questions that you can ask the panelists. I want you to think on these things and ask yourself, what type of president do I want and why? What type of republic do I want and why? What are my rights in the Constitution? Do I want them to be strengthened? And when you hear proposals coming in from the opposition or the ruling political party, I want you to ask yourself the question, what is the implication of this recommendation? What is the implication for the composition of the Senate? Do I understand these things? It's not supposed to be above your head. Ask any question that you have. That is why the panelists are here, to break it down for you, ensure that you understand it. No question should be off limits. And I know the dual citizenship is one that's taking up the news. JJ didn't have any position then. We don't have any now. But we can offer some guidelines on perhaps what we should be thinking about for dual citizenship at some point. So put your questions together and we will answer. Michelle Thomas is still not here? No? All right, so I'm going to start with Professor Trevor. No, I'll start with Mr. Michael Hilton, attorney at law, King's Counsel, because he has a great PowerPoint that he's going to be setting the context in terms of why we should care about what is happening. Casey, you will come here or you want to take the mic?
Good afternoon, everyone. Thank you, Michael. And if I may just use the opportunity to congratulate Mr. Tingle again for that excellent presentation. As Michael said, I want to spend the few minutes I have here at this podium by talking about why the Constitution is important. We have, unfortunately, not just in Jamaica, but in many countries, public that doesn't, generally speaking, doesn't think the Constitution necessarily matters to them or affects their lives. They think that the Constitution is something that is for the lawyers and the politicians, and that, of course, translates into constitutional reform. That process is something distant from them and doesn't affect them directly. Now, how do I move these slides? This one? So, why is the Constitution important? The Constitution basically does two things. It indicates who has the power to do what. So there are various branches of government, various public positions and offices, and they have different powers. And the Constitution defines who has the powers. And more importantly, I think, it also decides what checks and balances can be placed on those powers. Who restrains the powers given to the various people? Now, our system is one that results in the government having powers that are extremely wide, and government can pass any law, make any decisions in relation to employment or government and so on, restrained only by the Constitution. In some systems, the very structure of government creates a check and balance. So that in the US, for example, you have a Congress which is not necessarily controlled by the same political party as the president, as is the case right now. That is in itself a check and balance. And in fact, in some countries where it's the same party, there's a culture of not automatically following what the president or the prime minister does. In our system, the prime minister always controls the Senate and the House. So the prime minister controls the parliament. And we don't have a culture of backbenchers voting against the prime minister. So effectively, you have a situation where the Prime Minister has extensive powers over the legislative branch, the Parliament, and over the executive branch. The only restriction on his powers and on the Cabinet's and the government's powers is the Constitution. And the Constitution sets out the things that the government cannot do or the things that they must do. And it seeks to restrict the government's powers in various ways. And I'll just mention a few of them. There is the Charter of Rights, the section of the Constitution that sets out the fundamental rights of every citizen. And I had a look at the JFJ's excellent pamphlet that summarizes a number of these rights and explains them briefly. Life, liberty, freedom of religion, and so on. It has a system, the Constitution does, where I've just mentioned the Parliament and the executive. But the other branch of government, the judges, are a critical part of our system because that's the body that needs to be independent of the executive and Parliament, and the body that the typical explanation of the judge's role is they interpret the laws. But it's more than that. They enforce the laws, they enforce the Constitution, and they enforce the human rights that the Constitution gives us. Because the Constitution giving us those rights doesn't really assist us unless there's somebody there to enforce them. And that's what the courts are there to do. And it's important for the purposes of the courts and the judges being able to carry out that role, that they have the independence and security to be fearless and independent in carrying out this role in relation to the government's powers over the people. And this discussion that has taken place in relation to constitutional reform has certainly increased public attention and public interest. And we need to recognize that it's not surprising that there's limited interest in the Constitution and people feeling it doesn't necessarily affect their lives. Part of that is because of the document itself not being very readable. It's written by lawyers for lawyers, not really written for the people. And also, to some extent, it's the fault of the lawyers and those of us who should spend more time and more effort in explaining and getting people involved in the Constitution and in some of the issues that are on the program for today. And that is why organizations like JFJ and meetings like this play such an important role in educating and informing members of the public about their rights and about these issues, especially at a time like this when there's a discussion about constitutional reform. And we need to ensure that such reforms as take place strengthen our rights and strengthen the public's position under the Constitution and do not weaken our rights in any way. Thank you.
Thank you so much to Casey Hilton for sharing. And, you know, as he was speaking, people tend to think that, as you rightly said, the judges are only there to interpret. No, our system goes a little bit more. And Casey Hilton himself have been a part of challenges that have seen the judges not only interpret the law, but really some slight judicial activism have taken place, some would argue, which is a good thing, because when executive branches and the legislature act, because there's fusion of power between the two, the judiciary as the independent branch of government of the state is there to ensure that the Constitution is respected fulsomely, right? So to continue, we will go to Dr. Maziki. Is it Fame or Tame? Fame, okay. I don't want Westwood to haul me, you know, for mispronouncing the H's, but please come. And she's a political scientist, so we are properly represented. Thank you.
Good evening, everyone. So I want to speak from the perspective of something that concerns me, and it is the level of participation and interest that the public has in this issue, as well as I want to expand a bit this conversation around human rights and to think through this in terms of the majority group, the people of African descent in Jamaica, but that is not to say that it is meant to suggest that rights accorded to that group are not meant to be generalized and should say something to us about the state of the nation in general. Now, I want to begin from the perspective that is offered in the report of the Constitutional Reform Committee that recognizes as a problem that there is no preamble in the Jamaican Constitution. And they recommend that to remedy that, an expert group of a poet laureate and other students of literature, including a musician, be constituted to determine what the Constitution's preamble should say. But I want to ask, what is to guide these students of beautiful words in determining what the preamble should say? For me, deciding on a preamble is actually an opportunity for our Constitution to become a living document, relevant to people's everyday lives. That is, of course, if it becomes an expression of the common good and the popular will, a statement of we the people. There is no we the people in the Jamaican Constitution. A statement of we the people is an expression of the popular will as well as an agreement between the state and citizens about the obligations of the state to protect the citizen, the kind of society that we want to build, and the values that we think will produce the outcomes that we desire. It produces a social contract, if you will. We can think of the agreement in those terms. Our concerns about the Jamaicanization of the Constitution, therefore, should not be limited to determining that our elected officials should be citizens. It should also think about the entitlements of citizenship that are captured in the Charter of Rights, and I agree with JFJ's recommendation that these should be expanded, but I also think that the expansion should consider the differences between individual rights, or individual human rights specifically, and collective rights. There was an African who was enslaved named Olaudah Equiano, who was able to secure his freedom. He was a sailor. He traveled throughout the Caribbean and the United States. And one of the things that he argued in his publication, his biography, was that he could not be free in the midst of slavery. And we learn from this that we, his descendants, have a history that is tied to collective oppression and by extension also a common destiny that is built from that brutal history. To speak of the common good and collective rights in Jamaica means correcting the legacies of slavery and colonialism here. It means contending with the fact that when people say we want justice, they don't just mean before the courts. They mean they want respect for the person instead of violence, control, anti-blackness, gender inequality, class cleavages, and political tribalism. When they say we want justice, they mean also social goods like bridges, health care, including reproductive health, social security, and access to natural resources like the land, beaches, and water. In historical context, therefore, collective rights must include protections for people of African descent related to their dehumanization in Jamaica, such as we have seen anti-black hair discrimination in schools, and this would relate also to private and public bodies. It would include a right to education which recognizes historical trauma and the need for reparations and reparative justice, as well as the protection of ancestral spaces and practices. Whereas we have some appreciation of workers' rights in Jamaica, I would wish to add the right to leisure, rest, and free time. This is important to reparatory justice and improving the condition of people of African descent whose ancestors came to labor as enslaved people and got little rest. Possibilities for rest and leisure are tied to collective ownership of land, water, and environmental resources. This would serve as a mediator of individual property rights, which are enshrined in the Constitution, in that I think it's important that we recall that property rights and land conquests that have specifically discriminated against people of African descent, or the majority group in Jamaica, who were themselves property and who have been impoverished by their history, do not necessarily serve that majority group. For those without wealth, their access to land and its resources are limited. And this is precisely being played out in the privatization of land along the coast in the interests of tourism investors as against the people's right of access to the beach. I'm going to end where I started, and that is on the question of how students of beautiful words will come to their understanding of what our preamble should be. The recommendation to leave the task to experts points to the need to deepen popular participation in our democracy. And we have to find a way to inspire people, to engage them in that process of deepening their democracy. It is important, even after the report has been tabled, and if we are to move on from phase 1 to some other phase, to have reasonings about the social, economic, and environmental values needed to guarantee the people as a whole and generations to come to have access to the nation's resources. It was never meant to benefit those who labored it, and critically also to guarantee them participation in decision making. And for me, that also includes our diaspora. They too have to be a part of the conversation because they are critical to, the social safety net in Jamaica, the history of Caribbean movement of people in search of better lives and circulation throughout the region and elsewhere. So it doesn't serve us to exclude them. We could think of this beyond the thinking around what political institutions need to be changed in the present, just the debate around the Senate and the form of presidency, to including a people's representative assembly, a body that could, for instance, be debating the values of our Constitution, be proposing legislation, be partaking in gender-sensitive and popular budgeting. And as such, I think critically, how we approach reform is as important as the place that we arrive at in the end. Thank you.
Thank you so much, Dr. Thame. One of the things that stuck with me as she spoke was just the importance of understanding our political and social history. Because after 300 years of enslavement, we have to ensure that a constitution reflects that reality and our current social and political context. And that is why there is no blueprint to constitutional reform, because it has to be based on the will of the people, the demands of the people, and the context within which we live. So as she was speaking, I was taking my notes. The right to leisure, free time. Again, after that 300 years, I think we deserve it, yes, as a people. I will turn over to Professor Trevor Monroe, whose books I had to read And now I read, not because I had to or have to, but because I enjoy reading them. No longer as a political science student, but as someone who loves the written word and political history. So, Prof?
Thank you very much, Michael. Sisters and brothers, good afternoon. I want to focus in my initial remarks on a matter of great concern to us now and of much concern to those who formed our Constitution so many decades ago, and that is the issue of how do we control our politicians? Most of all, how do we hold our Prime Minister to account? That issue was broached in our independence constitution making process on the committee itself. How do you ensure that the Prime Minister's power are not dictatorial, and to that extent, how do you curb them? In that regard, I want to refer to the actual notes of the Independence Constitution Making Committee, which I had to go through those hundreds of pages for my own doctoral thesis. The initial concern with the dictatorial powers is expressed in the Independence Making Constitution Committee, none other by Norman Manley himself. Norman Manley says, and here I quote, and this is 1961, to give the Prime Minister the absolute power to get a dissolution of Parliament would allow him to bully, Norman Manley's words, not mine, to bully the entire cabinet, to say nothing of the parliamentary party. End of quotes. Manley's first vice president in that same meeting at that same time went further. He argued that, and here I quote again, in truth and in fact, a prime minister is a dictator for 5 years. Not my words again. The first vice president of the People's National Party in commenting on Norman Manley's concern. An opposition member at that time, then Edward Seaga, later to become prime minister, strongly endorsed the first vice president of the PNP's view, and here's what Seaga said. Quotes, quite right. Only one minister must rule. And I would refer those of you who want to see more of that conversation to my own book that Michael referred to on page 169 and 170. The dictatorial powers referenced by the constitution makers, I want to expand because many of us may not be fully aware. I mentioned 4 of those powers. 1, to call a general election at any time that the Prime Minister considers it expedient to himself and to his party. Not necessarily good for the country, but expedient to himself and to his party, within the 5-year period that the Parliament has alive. This includes, ladies and gentlemen, the power to call a general election if the Prime Minister anticipates, as happens in parliamentary democracies, that the majority on his side would wish to change him for somebody else, a deputy or otherwise. It happened a number of times in the United Kingdom. Prime Minister May, Prime Minister Thatcher, they changed the leader, and the leader, former leader, would have to concur. In our context, in our constitution, if the Prime Minister apprehends that anybody else in his majority is going to move a vote of no confidence in him, alternatively, following that vote of no confidence, he can dissolve the entire Parliament instead of handing over, as the majority party would then wish, to his deputy or to someone else. So that is the first power we need to look at, and that was a big concern for Norman Manley. The second power, the Prime Minister can name as many members of Parliament as he wishes to the Cabinet. What this would mean, as it stands now, 40-odd members of the majority party could be named to the cabinet. And what this does is officially and formally silence any criticism from the backbench, as it is called, of the parliamentary majority. Thirdly, the Prime Minister and the majority can amend clauses of our fundamental law, the Constitution, without any prior notice in respect of the ordinary clauses of the Constitution. And we saw that last week in relation to the clause that deals with the enacting clause of bills of parliament. Government brought a bill. It was passed within a couple of hours, despite the abstention of the opposition and despite us, the people, having no notice of it. Completely legal, because this particular section of the Constitution is ordinary and not entrenched in any form, and subject to parliamentary majority. The fourth power I want to mention is that the Prime Minister, in effect, appoints the head of state. Now the Governor-General, soon to be styled, if this process continues, the President. And we call it ceremonial, but let us be clear. It is the Governor-General, soon to be the President, who has the authority to appoint on his own discretion the independent members of the Electoral Commission of Jamaica, the commissioners of the Integrity Commission, the public defender, the political ombudsman, and a number of other positions. So that ceremonial position, nevertheless, appointed by the Prime Minister, has the authority to make important changes in the structure. Over the years, both deliberations in and outside of Parliament, in the Constitution Commission of 1991 to 1994, in successive joint select committees of Parliament, in public representations, and various submissions, including agreements among different Prime Ministers. Agreements certainly from Prime Minister Seaga, Prime Minister Golding, Prime Minister Simpson-Miller, and Prime Minister Patterson. A number of measures were proposed, some agreed, to curb what they call dictatorial power in that Constitution-making committee deliberation. And I want to mention some of the measures proposed, some agreed. One, establish a fixed election date. So you and I don't have to wonder when I'm going to call election. That's in the Constitution for both general and local government elections. This was promised in the Jamaica Labour Party manifesto of 2011. It was also promised by Prime Minister Holness to be done in the first 100 days following the 2016 election. We still don't have a fixed date. Second proposal, limit the number of terms a Prime Minister can serve. Third, limit the percentage, and Seaga was particularly supportive of this in his later years. In his earlier years, he was not, but in his later years, he became fully aware of the dangers, more so the perils, of having too dictatorial power concentrated in one person and in one office. And one of the proposals that he strongly supported and was agreed on in the Constitution Commission was to limit the percentage of MPs a Prime Minister can name to the cabinet. Some can't name everybody and therefore muzzle everybody. Because once you're in the cabinet, it means you have collective responsibility for whatever the cabinet does, and therefore you have to go along with it when it comes to the Parliament. Thirdly, require concurrence by the opposition in the choice of the head of state. That was one of the proposals discussed and agreed on. Fourthly, and perhaps most significantly in my mind, it was agreed to provide for impeachment of public officials, including the Prime Minister, for misconduct. And here I quote from Jamaica's National Development Plan, Vision 2030, which came about after massive public consultation, public education across the length and breadth of the country. The National Development Plan, Vision 2030, states as follows. This is in 2009. Quotes, enactment of legislation for the impeachment and removal from office of public officials found guilty of misconduct, corruption, abuse of authority, or betrayal of the public trust. End of quotes. And that's page 124 of the National Development Plan. In giving effect to this agreement, on May 10, 2011, Prime Minister Bruce Golding stated in his budget speech in Parliament, and here I quote again, "The bill to make provision for the impeachment of public officials has been completed and is to be submitted to the Legislation Committee for final review before being brought to Parliament." 2011, we're now in 2024. Next, agreement to provide constitutional protection against parliamentary majority doing whatever it wishes to do, parliamentary majority manipulating, even abolishing independent bodies designed to check executive power, and Mike Hilton referred to that. To protect the Electoral Commission of Jamaica. That was said in 2006. Tomorrow morning, a parliamentary majority can abolish the Electoral Commission of Jamaica because it's not protected in the Constitution. Similarly, to protect the Office of the Political Ombudsman, that was passed in 2002. The Office of the Public Defender passed in 2000. Indicom passed in 2010. Each and all of those subject to parliamentary majority manipulation because they don't have constitutional protection. Once again, Prime Minister Golding indicated in his budget speech of 2011, quotation marks, "The drafting of the bill to rectify this will shortly be tabled in Parliament," end of quotes. And finally, and very importantly, because this one was actually done and agreed and we now benefit from it, to place fundamental rights and freedoms, as Mike mentioned and Maziki, to place those rights and freedoms of the people beyond infringement of the executive or any organ of the state, except that could be demonstrably justified in a free and democratic society. And that's not for the Prime Minister to decide, only the courts can decide whether it is justified if our right to freedom of movement, freedom of speech is being infringed in a manner that is consistent with the Constitution. That fundamental rights and freedoms, let us note, was implemented following admirable public education and discussion, such as we're not having now. Public education, Dr. Lloyd Barnett wrote a simplified book that anybody could understand. Thousands of copies were circulated so that people had a sense of what is in the Constitution and what needs to be done, ultimately leading to the Charter of Fundamental Rights and Freedoms. I conclude. The report of the current Constitutional Reform Committee of May 21, 2024, sisters and brothers, either ignores or rejects, in the context of grossly inadequate public education, grossly inadequate public consultation or explanation, they either ignore or reject these curbs on executive power, which our founding fathers, there were no women on that constitution-making committee, it's a point to note, which they said needed to be looked at in terms of the dictatorial powers of the Prime Minister. The dictatorial power of the Prime Minister remains, and with it, the inadequate ability of the people to hold the Prime Minister and the majority that he controls to account. This is completely unacceptable. Education around these issues, such as JFJ is doing, alongside meaningful consultation, must begin now. And decisions regarding these fundamental issues cannot be left to some indeterminate, unnamed second phase. We've been waiting on phases from 2006 for the Electoral Commission. This is not acceptable. There needs to be proper education. There needs to be proper consultation for us to respond and not to take the report of the Constitution Committee as anything final, but simply a matter for us now to begin to discuss seriously. Thank you very much.
Thank you so much, Prof. And I hope we were paying attention at some of the powers. And just to quickly reiterate some of the things that Professor Monroe said, and I want you to think on what you want as citizens. For example, the matter of the Prime Minister having the power to call the election whenever he or she deems it most expedient for their political party, whether you want a fixed election date. And just to say that having read the CRC's report, based on my understanding of their recommendation, is that rather than having a fixed election date that they deem would be too inflexible, the life of Parliament, which would end after a 5-year period, once the life of Parliament ends, within a 3-month period, the Prime Minister must call the election. I don't remember it specifying whether general election would, the local government election, sorry, would so apply. I'm just speaking from memory here, but that's one. Interestingly, having read the CRC's report, we the people want impeachment. We want some mechanism that can hold our parliamentarians and other public officials to account. Impeachment is one. Impeachment is a more legal process that would happen in Parliament itself. But what was disappointing is that the CRC's report said that impeachment can be too problematic, because we've seen in other jurisdictions that impeachment has been used as a political ploy, has been exploited. But the CRC did not even recommend or speak to the matter of the right to recall, where the power would be vested in we the people to say that if we have amassed a particular percentage of signatures in our constituencies, then you could remove a particular member of Parliament. It did not even acknowledge that. Before I get to our panelists, I just want to quickly summarize two critical aspects in the report that I want the panelists to speak to. We've been asking what type of president we want, non-executive or executive. An executive president is normally elected by the people, but where we're having this conversation of head of state versus the head of government, the executive president, those two duties are in one person. And there's danger in that, because sometimes if somebody is running up and down trying to get your vote on the political campaign, and then tomorrow you come talking about unifying us as a people, I don't know which hat you're wearing, whether you're wearing a political hat, your head of government hat, or you're wearing the hat of head of state. So that is why a lot of us say, let's focus on a non-executive president, which is what the CRC is recommending. But what is disappointing, having read the report again, the CRC simply states that the non-executive president will follow the governor-general model. Now, for the average person who is reading that report, the question is, do you know the existing powers of the governor-general? And do we simply want to replicate the existing powers of the governor-general? Because you do have some important powers, but do we want to strengthen them? The CRC report did not give us the courtesy of outlining what those powers are and what powers need to be strengthened, and whether or not we need to say that this new non-executive president, even if you consult with the leader of the opposition, consult with the prime minister, you should be free to depart from whatever advice they may have given. These are the things that we need to be thinking about a little bit more. What are those powers that the non-executive president would have? Another concerning recommendation in that CRC report, remember now we have 21 senators. The 21 senators, 13 of which are appointed by the ruling political party. The remaining 8 are appointed by the opposition. Firstly, I think that the recommendation reinforces a two-party system a little bit too well. But that's another conversation we can have on electoral reform. But what is concerning is that there's a recommendation to increase the size of the Senate from 21 to 27. Why is there a concern? The ruling political party would now appoint 15. The opposition would appoint 9. And the non-executive president would appoint 3. Let's do the maths. 15, 9, and 3. That's how many? 27. Work with me now, you know. Currently, you have critical provisions that are passed in law that require that 2/3 majority. Currently, to achieve that 2/3 majority at the Senate, you must get at least one opposition. I hear people talking about the CRC report saying that it retains that when it comes to making changes to the entrenched provisions, like the Charter of Fundamental Rights and Freedoms, whether or not you're making certain changes, for example, to the Director of Public Prosecution, those are entrenched provisions. It will retain where you need at least one opposition senator, but work with me now. You have other mechanisms or other changes that will be made, or laws that will be passed, my apologies, that would need 2/3 majority. For example, extending the state of public emergency. That's not an entrenched provision issue, no. That's something that already exists, and you're saying that when I call a state of public emergency, 2/3 majority vote to extend it beyond the 14 days will be needed. But work with me with the maths again. To get 2/3, which is roughly 67% of 27 senators, is 18. How much has said the government have now in the proposal? 15. How many the president have? 3. And how many the opposition have? 9. In other words, to attain 2/3, that is 18 of 27. So you can extend the state of public emergency, for example, without the opposition say. Why is that concerning? I need you to look at how this new head of state would now be elected. This new head of state, which is your non-executive president, the prime minister goes and consults with the leader of the opposition, and they arrive at some consensus. Then they take that name to the 2 houses of parliament, and they would vote separately in a secret ballot. And that is just reaffirming what the leader of the opposition and the prime minister agreed to. But say the opposition leader don't agree. You know what happens next? The 2 houses then vote by way of absolute majority. So in other words, simple majority vote. So you can have a head of state that the prime minister has installed. And if that head of state has the power to nominate 3 senators at the upper house, you ask yourself the question, are those 3 senators truly independent, or is there the possibility of those 3 senators ultimately acting on behalf of the ruling political party? Food for thought as we have the conversation. All right? Did I lose anybody? Are we together? I'm just going to share the mics. Now, as we have the conversation, I will just be fielding some questions to the panelists. And please put together your own questions so that I can share them when we get to the Q&A. With Casey Hilton, Michael Hilton on that one, to hear his perspective on whether or not we should be looking at directly electing our Prime Minister.
Is it on?
Yes.
Yes. Thank you. I am one of the persons who support that view. we have a system now where people don't vote for a prime minister. They vote for an MP, and then the MPs effectively vote for the prime minister. And what that means is you may prefer to have Mr. Holness as your prime minister, but to have the PNP candidate as your MP. You're faced with a choice where to achieve one end, you need to abandon the other. And what that does is perpetuate a system where MPs see their role as being supportive of the prime minister, supportive of the government, primarily and perhaps only, and not the constituency representative role that they ought to play. And I therefore support a system where you vote for prime minister separately, prime minister or president, whatever you want to call the office, the head of state, the head of government, and you vote separately for your MPs. Now, in an ideal world, you would have different votes, and you'd have different bodies supporting. But I appreciate that may not be the case. But nonetheless, that would be my position.
All right. Thank you so much. I know Prof has a thought, but I have a specific question to you, Prof. The one that you posed to me when you were sharing your thoughts on JFJ's proposal. Dr. Thame, do you have any opinion on this before I get to Prof?
I agree that direct election is appropriate. I think that in order to encourage participation, even while it is that voter turnout may be presently low, we have to think of the future. We have to think of the possibilities of engaging the public more and more in the political process. And voting is not the only mechanism, but it is one of the mechanisms. I see that JFJ's concern is that this will simply take the partisan form that the two-party system manifests. But it is possible also for independents to run in presidential elections and disrupt that two-party consolidation that has existed in Jamaica since the 1930s, really, 40s.
Yes.
Yeah.
All right. Thank you so much, Dr. Thame. Prof, you asked me a question when I had asked you to share your thoughts on a section in JFJ's. When you directly elect the Prime Minister, how do you get rid of that person, and what are the dangers?
I think that would be my concern. Obviously, your ability to elect the Prime Minister directly is attractive, because you then don't have to make that difficult choice between the constituency rep of the party, who you feel will be no good an MP, but he's in the party whose leader you wish to be Prime Minister. The problem with that is, if we now have a difficulty in holding to account and in controlling a Prime Minister who is indirectly elected, because it's the majority who puts him as Prime Minister, as head of the party in the Parliament, how much more we're going to be able to control a Prime Minister who will then say, "Uno, elect me to run the government, not the majority in the Parliament. You elect me directly." And therefore, my support with that, for that position, would have to be accompanied by the most stringent mechanisms for accountability, and one of which you mentioned, Michael, and that exists in some countries, the right of recall. That is to say, a situation in which a specific number of the electorate, a percentage of the electorate, can initiate what is called a recall petition. If you don't like how the MP is performing, they have promised everything and delivered nothing, you, in between elections, you don't have to wait, you don't have a permanent job for 5 years, can initiate a process to call that member back. And would have to have a similar kind of situation for a Prime Minister elected in that way. He couldn't have the same powers as he has now, because the dictatorial powers which the constitution makers themselves saw and were worried by, some of them supported it wholeheartedly, manly felt reservations, would have that much more difficulty in controlling that particular office. So I think that we'd need to think through different mechanisms for control and management and holding that person to account at the same time as we were to put forward that position of direct election.
All right. Thank you so much. Now, similarly, I want to ask the recommendation by some, and I think a vast majority of the Jamaican people would prefer to directly elect the non-executive president now. So JFJ supports the direct election of a prime minister, offering the caution of accountability while ensuring that the person is able to act based on the will of the people, so to speak, who would have elected that person. But accountability is important. But we do not support direct election of the president because from our perspective, the president ought to be the symbol of unity. And then if the non-executive president has some of the reserved powers that we would want, you do not want that non-executive president, when they exercise those powers, for example, having an impartial set of commissioners at the Integrity Commission, having an impartial public defender, hopefully the National Human Rights Institute, having an impartial set of people at the Electoral Commission of Jamaica. I think the fear for us at JFJ, when you have those powers that ought to be above the political fray, that the moment you are directly elected by the people and you're in a campaign, that your views and the perception that you are politically biased may happen. That is our view, but I want to ask the view of the panelists on the direct election of the non-executive president. Dr. Fame, let me start with you.
I thought that's what we were talking about before. But, you know, for me, it's important to look at the system in a kind of integrated fashion. And I think one of the things that Prof. Monroe said just now, which is important, is that it's not just about direct elections. It's also about, okay, so what is the role of this specific office? And what are the mechanisms that are put in place to check and balance the powers of either house or either authority within the state? So, you know, direct elections could, on the one hand, improve participation, but it could, on the other, entrench dictatorial authority, because this individual would argue, you know, I have been elected by the people have spoken, etc. But it's really important to look at the whole system and how it works to counter that, you know, dictatorial authority.
Thank you so much.
Well,
Yes?
if I can just start by saying, I totally agree with the comments of both my fellow panelists on the question of greater accountability and restraint. So whether it was a directly elected prime minister or not, you need to have increased restraints. And a recall process is an important part of that, and many of the other things that we discussed. Now, when we're discussing direct elections, and I like your comment about that's what you thought you were talking about, because in a way we were. If you have one person, one head, which is whether president or prime minister, the views I had expressed earlier about direct elections would apply there. If you have, though, what you are considering, which is a prime minister and a president who then acts as a check and balance,
Yes.
I support JFJ's position that you'd have a directly elected prime minister who is the head of government, who is the person who has the governmental responsibilities and functions, while the governor general has has powers really designed to me, more check and balance, but also, I think, what you've said about the national unity issue. And what then gets important is how is that person chosen. I agree not directly elected, but less of a discussion about how that person is chosen, not by the prime minister.
which we go back to the overview I gave earlier, which is why we're concerned about the proposal coming from the CRC. Prof, I know you've scoured through that report. Do you have any concerns about what is being proposed? I know you have all your notes written up there.
Look, the hard copy of this report is 52 pages. Schools Challenge Quiz. How many pages do you think in this 52 is devoted to the issue of public education? Half a page. Half a page of 52 is devoted to the issue of how do we explain the kind of issues that we're talking about here before asking the people to vote on it. This to me is absolutely incomprehensible, especially when we have two excellent experiences in our own history. The way in which we did Vision 2030 in 2007 to 2009, and the way in which we did the Charter of Fundamental Rights and Freedoms between 1991, the number of joint select committees, education, Lloyd Barnett's booklet, and we have far more sophisticated multimedia channels now. I ask publicly, because it's not in the report, in the budget of how much trillion that we just heard read and accepted, what is the amount in that budget assigned to educating and consulting our people on the most fundamental decision they can make, which is the basic laws of the country? I really would like to know, because those who have looked at the budget tell me they can't find it. I'm still inquiring. Because we have to be careful. I don't want to use the Jamaican original ship, you know. But believe you me, if you are telling me, because I know you don't want no British monarch, I know you don't want him Trevor, I know you don't want him Horace, I know you don't want him Lynette, none of us. So make we get rid of him. And then later on, no date, no unbreachable commitment. Later on, we're going to deal with the entrenchment of the Electoral Commission. Later on, we're going to deal with the Privy Council. That's not only logical in the latter case, it's self-defeating. Suppose, for argument's sake, we were to vote to end the monarchy in respect of the proposals that are before us, but keep the Privy Council until second phase or some other time. Between the point where we end the monarchy and come to decide to withdraw from the Privy Council, during that period, Mike can confirm, the monarch's court can rule unconstitutional policies proposed by our cabinet, agreed to by the parliament and by the Jamaican people, but somebody wants to appeal to the Privy Council, the court, which remains our highest court, can then overrule even after we have gotten rid of the monarch as a member of the parliament or as head of the executive. So I think what I'm really saying, Michael, is that the issue of making us understand the options before you ask us to vote on it, it's just basic. If I have a member of my family, or you have a member of your family who is not well and who has a real health crisis, and there are difficult choices with benefits and risks, it makes no sense for the doctor to consult you. Do you want your family member to have dialysis or a kidney transplant? Without explaining beforehand at some length, answer my questions as to what are the risks and benefits of a dialysis, what are the risks and benefits of a kidney transplant. But we are now being asked to
Yes.
vote on a ceremonial president whose powers are real, if it's just to take over from the Governor General, even though they are not what many of us would wish. That ceremonial president chosen by the Prime Minister, if we go by this thing, will have the power to say, all right, the 4 members of the Electoral Commission, the selected members, we don't want you again. I could put my people. Similarly, the commissioners of the Integrity Commission will not behaving on themselves as I would love you.
Yes.
Change them. Put in my people. So we are in a real situation where we have to put an end to this process disguised as consultation until we get, as the civil society organizations have called for it. We need at least a year of public education.
Before we continue, Prof, one of the questions that have been put forward, because we tend to be talking about the pure presidential system as we know it, that we're more familiar with. And someone asks, and I think we do a disservice by keep on using the word hybrid, don't explain what hybrid means. But people have asked me, what about a semi-presidential system? But the answer I give still to individuals who ask that it ultimately comes down to the constraints that exist just the same. Because you can have a president and a prime minister together, but if the president can just hire and fire a prime minister at will, then you're back to square one with a head of government and a head of state that ultimately does whatever they want. So it comes back to the accountability systems. And I think the question very quickly before I segue into CCJ conversation, what is your position on the impeachment? I know we're for the right to recall, if I'm hearing correctly from the panel, but the matter of impeachment, is the CRC correct to say that impeachment is too much of a political exploitation and therefore let's not go there? As we've been seeing in the United States more recently with President Biden and what has happened, should we not be looking at impeachment based on the caution of the CRC? I'll start with Prof and then go down the line.
Just posing the question, as Michael has done, quite correctly, highlights the problem. As a political scientist who has taught institutional politics for 40-odd years, I don't want to answer that question until I have looked at impeachment experiences elsewhere. It's crazy. I want to know the right of recall exists in Belize. It's the only CARICOM state that has that right. I want to know what is the experience of the Belizean people regarding the right to recall their member of parliament. The British, whom we copied so much from, they instituted a right of recall in 2015. I want to know how that has worked. And similarly with impeachment, we hear about the United States, and believe you me, anybody who now wants to replicate what is going on there in terms of the system of checks and balances, which are, just in a real mess. We need to, if I may just say this, we need to value some of the gains and the advances and the example we have set for the world. In 2016, the majority party in this country won the election by less than 1% of the popular vote, 0.5. Not a word of protest, no demonstration, no insurrection, because we have confidence in that electoral commission which we set up. So I'm saying, Michael, I want to give that more reflection. I can't come to the conclusion that the one paragraph in this report says that no impeachment because it is a juridical process that is subject to political manipulation. I want to see what examples exist in the world where that danger has been checked by other kinds of qualifications.
And just to indicate, before we segue to Dr. Thame, there is an impeachment process in the Local Governance Act of 2016 that is speaking to how to get rid of a mayor. However, that's not the constitutional provision. But should we be looking at even our own experience and ask ourselves, since that provision has been there, has it ever been politically exploited?
I'm glad you mentioned that. Pardon me, I beg you. Here is a situation where the same parliament that says impeachment can't work for them passed a law in 2016 in relation to directly elected mayors in the municipalities that gives the people in those municipalities a certain percentage of the electors the right to initiate the process of impeachment of the elected mayor for misconduct. So it can apply to them, but not to us. I just want to point to that inconsistency.
Thank you. Dr. Fame?
You know, I agree with Prof. Monroe that sometimes it's difficult to give a yes or a no to a particular recommendation. And I think it's important to look at the whole system, but also the system in context. Yes, we have concerns about partisan exploitation in terms of our history of politics in Jamaica, and those things should be considered when making decisions. But I also think that it is important to consider that institutions are not going to be perfect, and that in deciding on how to transform institutions, we also have to think about what measures we put in place to ensure that they do not become corrupted or they cannot be exploited by those that would have an interest. So I wouldn't say no to impeachment. I would say that if we consider that, then we should also think about how to put in place the kind of law that would at the same time minimize the prospect of it becoming a political tool.
Yes, absolutely. Safeguards, always. Thank you.
Yeah, and also the rejection of it out of hand with a sentence, that this can work. It's part of the education process that Prof keeps talking about. How many people know or knew that there was an impeachment process in the books in Belize? This is not, Pakistan or somewhere far distant from us. We have experiences or the opportunity to learn from what else has happened. And that's the kind of education that's not being taking place. So I certainly agree with the comments that have been made here. That is something that we should explore. A lot of the changes that are proposed, while there's disagreement between the two political parties, the truth is they agree on some of these things that the public should question. Yes. Not just because the two parties agree it's fine, but the public should question, and this I think, is one of them. And can I just say something personal? Prof is not 40 years, he's been teaching political things. You taught me and it wasn't 40 years.
Prof, you've been around for a while. One of the things that people have said, if a referendum is to be held today, I will not be voting if I'm unaware of my final court. Whether it remains somewhere that eludes me, whether it goes to another foreign court, as some people have been calling the Caribbean Court of Justice, or should we have our final court? And let me just quickly say, and this is going to be seeming as if I'm contradicting myself, JFJ's position is that there needs to be severing of the ties to our former colonizers. We should go to the Caribbean Court of Justice. We've invested $27 million in that court. There are safeguards already. We have one of the justices, Winston Anderson, born and bred, I believe, in St. Ann, my parish. So this thing that we've been hearing, that it's too foreign, I need us to challenge that. But before I go to the panelists, us at JFJ, we believe that only the conversation about a final court and CCJ should be on the table. However, this is where my contradiction comes in. We're not yet ready for a final court. And nobody knows better than Casey Hilton why I may have made that statement. If you look at why he has made several challenges, it's because of the challenges that exist here. But I will start with Casey, the King's Council that will soon become the President's Council under the Republic.
Senior Council, probably.
Okay.
But CCJ and Privy Council. Some people ask reasonably, why are we moving from London to Trinidad? The CCJ is our court in ways that not just because Jamaica and Trinidad are part of the same region. A fundamental reason why the Privy Council is not our court is we have no say, no input in how the judges are appointed, in how the court is run, in the regulations and rules and procedures they put in place. In the CCJ we do. It's not just a matter that there is a Jamaican judge on the CCJ, which is important, but how was that judge appointed? The CCJ has a set of rules and commissions and protocols and guidelines that operate, that we had a say in, and we have a continued say in. And with all the criticisms people make of the CCJ, a lot of them are due to ignorance of how the thing is set up. And let me just give you two things. Michael mentioned funding and $27 million. What has happened there is, in order to guarantee the independence of the court and that you don't have a situation where the court is created and then member countries don't put in the money to keep it running. When this court was created 20 years ago, what was it, 200 million US dollars, whatever the number was borrowed. All the countries had to guarantee this loan, which created a fund, and that fund and the income from that fund has run the court over the years. The countries are not required to continue putting in money because they have a debt that they must pay back. So that's the first thing. The second thing is, a commission was created which has the responsibility of choosing the judges. That commission is made up of 9 members, and when you look at how the members are appointed, they're not appointed by politicians, they're appointed by institutions that the region can have confidence in. So for example, the universities and law schools of the region get together and choose 2 members. The bar associations of each country get together and choose 2 members. The public service commission of each country, the senior public servants of each country, represented on the commission. Those are the people who have come together, who choose the commission, who then chooses the judges.
And Dr. Lloyd Barnett was one of those early members of the...
He was the deputy chair.
Yes.
I replaced it. It's a body that is very much us. And what happened, if you can give me a few more minutes, this year, really this month, is a prime example of the kind of practical problem that you have with the CCJ. The way our court system works is you go to court for a case, 1 judge hears it. If you are dissatisfied with the result, you appeal to the Court of Appeal. 3 judges hear the appeal. If you are dissatisfied with that result and you appeal higher up, whether the Privy Council or the CCJ, usually, historically, 5 judges hear it. That's not just a Jamaican or a Caribbean thing, that's for courts around the world. Sometimes it's more. In the US, the highest court is 9 judges hearing it. But the number of judges keeps going up. The Privy Council decided recently that instead of having 5 judges hear the case, 1 judge, one of their judges can look at the appeal and say, this appeal is no good. Or 3 judges can hear it and dispose of it. No input from the people who are supposed to be our court. They just did it. There was a lot of complaint, and they then said, let's have a consultation process. Let's ask people what they think. So after they've been doing it for months, big outcry, they've withdrawn it. That's the kind of problem that you have because they don't think that it's our court, really. They're in charge of it. We have no input, no control.
And the greatest importance as well in that senior council is that a change was made that had implications for our own supreme law.
It was contrary to our constitution.
That we had no input. So there was a possibility now that Parliament now would have to be thinking about, do I change the constitution? Because people are foreign, made a change that will impact our supreme law. Just to really emphasize to our listeners what is happening there. All right? Let's segue to the other two speakers, CCJ versus Privy Council, because people on YouTube complaining that they need to put forward their own questions.
Well, I'll just say briefly that I am for the CCJ. I mean, I can't speak to the legal question, but I think that we would benefit from regionalism. I think that Jamaica has to think of itself historically as well as in terms of the future, in terms of how we build institutions as a region and benefit from integration with the Caribbean, and the CCJ is one institution that represents that.
Yes, thank you so much. Prof?
Could I agree with all that has been said on the CCJ? And also to pose a question to the public here and online. What happens if tomorrow morning the British government decides that the Privy Council should stop hearing appeals? That's their decision to make. So we're going to then run round, go to Port of Spain and beg, well, you know, we had reservations about you, but the British tell we must leave them, so we have to come to you. It is invidious. It's an invasion of our sovereignty, which is no longer acceptable. Secondly, we put money, we invested in it. Thirdly, I recall very well when I was in the Senate, we debated, along with members of parliament here and in other Caribbean countries, what the rules should be to ensure that judges' appointment would allow for independence and all the other criteria that we'd want our judiciary to have. So I'm all for the CCJ as soon as possible and not in no second phase.
Yes, agreed. So it's time for Q&A. So I hope you're excited to ask your questions. As we make our way to the mic, please come. As you make your way to the mic, there is a question in the chat. Please ask one of the lawyers this question. Is the government of Jamaica by legal construct a corporation named State of Jamaica?
Repeat that, please.
Is the government of Jamaica by legal construct a corporation named State of Jamaica?
No. No, it's not a corporation by legal construct. I'm not sure what the question is getting at, but the answer to that would be no.
Okay. And another question before I get to the gentleman on the mic. I heard this in the public space and I want to ask it. If we become a republic tomorrow, does it mean that third political parties automatically will be voted into the House and then we become a coalition government? Prof, I will give you that one.
I'm trying to understand. If we become a republic tomorrow, following a referendum, God forbid, without us having the kind of public education first, then it wouldn't change immediately the status of the existing political parties, nor other elements of our constitution regarding the right to vote and so on.
Thank you so much.
Yeah, man.
Want to state your name and the question?
I am Eru Aishaka Musa Menelek, and I represent Rastafari indigenous people. Now, when we get the thing named emancipation, 1834, 190 years till now. Now, the white man, they may get 20 million pounds for share up. Black people no get nothing. No land, no nothing. We are saying now when the Republic come, and these land, when known as crown land, must be known as the people land, and it must share up out the people. And the people must get the land. Black people no get nothing, no, you know. So, Dr. T.M. start to touch up on the thing about land for the ancestors and I people. We need to find out now if we are going along the road to claim the land as the people land. A 2.4 million squatters there in Jamaica, you know. 2.4, because people will pay rent as squatter too. Them live upon the benefit of the landlord. Them a squatter. You understand? So we want to know how the land go.
Any of the panelists? You want to come so we can answer the question for you?
Give
Yes.
thanks.
Any other panelists want to take that? Dr. Thiem?
I think that our Rastafari brethren was really questioning, you know, the maldistribution of wealth and the questions of, you know, who owns Jamaica really. And I agree that we should think of so-called crown lands as the people's land, and determining how to deal with that land, therefore, has to be something that is put to the people. I think we have to be very careful about the ways in which the state or governments make decisions about selling lands, selling resources, use of natural resources like water, you know, environmental issues like mining and what that means for water, and also, you know, people's ancestral rights to places like the carpet country. So, you know, I think I am in agreement with the perspective.
All right, thank you so much.
Give thanks.
Thank you. Wait, we had 1 second, she was here. You have a question? Please.
Dr. Tim, thank you very much for raising the matter, the question of, thank you, of the relevance of constitutional reform to regular people trying to live their lives daily. I want to point out here that I have the fortune of having been around when there was a new constitution, when there was vote allowed for my parents. My parents were optimistic when the vote came. My parents continued to be optimistic when independence came. But the independence, the emancipation, the abolition did not arrive and still has not arrived. Where is the hope then for people that constitutional reform will bring any greater abolition, emancipation? Because we still have the 80-20. We still have people who tonight going to bed without a meal, on bed, quote unquote. So what I really want to know is how then are we going to make all of this relevant? Or is there a risk that once again it's a discussion, a debate that takes place uptown, and then other people get called in afterwards and with a done deal?
Before I segue to the panelists, just to say I'm happy you asked that question, because I've heard public statement that laws are not made at bus stops and so on. This is where the conversation happens. At the bus stop, the corner, before it gets to Parliament. So I think the need and the demand for public education is important, because consensus between two political parties is a critical part of making the law, changing the Constitution. But I always say this: they act at the will and at the instruction of all of us. So it's when they meet us in spaces such as these, and when we are informed, they act based on what we demand of them. That is my point before Prof comes in.
Yeah, I fully agree with you that there has to be an explanation, convincing, between changing from a monarchy to a republic, and how is that by itself going to impact and improve the lives of the people. And I can answer immediately, that change alone will have no impact. This is not to say it isn't important. Symbols are important. There are so many of us, you know, the flag is an important symbol for us. Those of us who went to school, if you tried to change the St. George's College symbol from light blue and white, you would have a serious problem with those who have graduated and those who remain, because the symbol is what we identify with and what energizes us to act. But by itself, we need more. And that would need an explanation that there are constitutional monarchies where the people are living much better than we are in Jamaica, and there are republics where the people are worse off than we are here now. So that change by itself does not impact the political and economic and social policies which are going to help to reduce the extraordinary gaps which are widening every day between the few wealthy and the majority of the people. That requires a discussion of the kind of political economic policy which would be important. And in that context, how do we structure a republic that would allow the people's views and the policies to impact what the government does and what the government doesn't do? And that has to do with how do you structure a participatory democracy as distinct from just a representative democracy. And that's the kind of issue I'm glad you raised, that the Constitution Reform Committee, there's no mention of it, no discussion of it, because what they want is to get us to this symbolic, important change and left everything else in the hope that we will trust them to do what is right to improve the quality of life of our people. That's not acceptable. Yes. We need to know now.
All right, next.
Thank you very much. This has been a very
good night,
good
Miss
panel.
Lynette.
Good night, everybody. I want to ask whether the activist judiciary and the political scientists and the advocates will support the fact that despite independence, despite all the progress that has taken place, when it comes to rights, women's rights are not being advanced in the country. And therefore, if constitutional reform must make sense, it must advance the substantive rights of women and girls. Everybody knows that there are gender social norms that influence what women can do, opportunities that women have. Although the law says we are equal, there is so much that shows that women don't have equal rights in terms of the political process, in terms of access to finance, in terms of how we are regarded, in terms of violence and so forth. The host of disadvantages that women face as the majority, 51% of the population, it's a tremendous issue. So the question of gender justice and justice that elevates and promotes the security of women and girls is something that the Constitution must, in my view, advance at this stage. And there are certain specific proposals that we want to make and that we have documented that must go forward. Briefly to say that the report, the only reference to gender that I've seen in the report was made by Sir Philip Sherlock in his preamble. And even the chairperson of the committee does not put gender in the laudable flowery language of the preamble. And there are lots of things that need to be involved in the preamble that opens the spaces for discrimination against women to be advanced through specific measures. Thank you.
Thank you so much.
Are
there any responses?
I'm glad you started the presentation, the question, by reference to activist judges. Not only do we need things in the Constitution to address inequalities and rights, but you also need to have citizen action. Because you can have things in the Constitution that are meant to protect rights of women, of girls, of other persons, but that don't get protected unless somebody takes some action with it. Because the courts can't just get up and hear a case.
Absolutely.
We need to test things. Because I spoke earlier about the public defender, for example, as one of the bodies that assist in this, our citizens also have a duty, both to speak up about the things you want done in the reform process, and after they're done, to then take action to make sure that they're implemented. So,
Absolutely. Thank you.
Right. Thank you so much. Future attorney on the floor. Oh, no. Okay, you're assisting.
Oh, yeah. Right. Good evening,
Can
everybody.
state your name and the question. Go ahead.
My name is Brother Lance Tahuti Watson. I represent the People's Political Party and the Ethiopian World Federation, Inc. My question is this, that I believe there is an effort to confuse the people because the constitutional reform being referred to in the report occurred in 2011. It is the Charter of Fundamental Rights and Freedom. The impression being given is that we are recreating the Charter. And this conversation is about amendment to specific sections of the Constitution. It is not about a constitutional reform. And so this is a problem that I have with the report, that it's confusing the people to think that they're actually believing they're getting a new constitution when it already exists. And more than that, the issue is this, that for the law to be binding, that is the Charter, it must be promulgated to the people to know about its effect, how it works, what are their rights, how to exercise them, and how to get a remedy. This has not been done. You mentioned about the public education in the report of being only a few pages. That is the problem. It's not public education, it is proclamation. All on the panel have been involved with my matter. I've been involved with this Constitutional Court for the past 15 years. I have a matter from the High Court in the United Kingdom. It's a probate matter. A probate matter. What it is that it's a probate of my parents' estate to be administered by the court in Jamaica. This was maladministered. It went to the public defender, and they too started an investigation and they maladministered it. I then came to Jamaican for Justice. I came to National Integrity Action, also Professor Tame, and also Mr. Michael Hilton. Under the Charter, you should have advised me or directed me how to get a remedy in the Constitutional Court. You did not do so. I did it by myself. I am a creature of the Constitution, of the Charter. I filed a 1901 application and a 1905 application, which was heard by Judges Pusey, Linton Pusey, and Justice Morrison in the Court of Appeal. They gave me no satisfaction. I am now banned from all courts in Jamaica. I'm banned from Parliament, every public building, and right now I have a matter in the court called an appeal against the registrar, where she will not.
But I want to be able to help you though, because we're getting a little bit long-winded. The question you're asking is around the remedy that you would have in the Constitution. I'm trying to make sense of it.
Right. Yes. I filed a constitutional claim against the government of Jamaica. I filed a 1901 for my right to be remedied by myself, and a 1905 when I went to the Court of Appeal. I got no satisfaction. I'm now back in the Constitutional Court and the Court of Appeal with a Form 24, an appeal against the registrar. My question is this: why am I not being allowed to file my application? I'm banned from the court, I'm banned from filing an application, and the registrar, when
all right, so let me just to cut you a bit, because we have several people.
Right.
I just want to be, I'm going to turn over to Mr. Hilton to answer.
Okay.
But I'm sure he won't be able to answer to your specific case.
No, I think he can.
Mr. Hilton?
Because I came to you, Michael Hilton, in 2015 with my complaint of my rights being abused. I asked for a remedy. I asked for ex gratia relief. And you told me it doesn't exist, but it does. It's section 42 of the Legal
So he will respond to the matter of constitutional relief.
What I want...
No, so we have to pause one second. Allow him to answer the question.
My question is this: Why am I not being allowed to file my application in the registry of the Supreme Court?
This relates to matters that are before the court, and the court has made rulings on them. So we can't take advantage.
No, we have to, excuse me, respectfully, respectfully, we have to allow, excuse me, respectfully, we have to allow the others to go ahead. We can't respond to personal queries publicly. All right? Yes, go ahead, please.
Good night, panelists. Good night, moderators. Good night, audience online and audience in person. My name is Sarah, and I am representing the Love March Movement, a Christian youth organization, also an alumni of the University of the West Indies. So as this process comes about changing our constitution, I would love for our constitution to always be grounded in reality, in truth, and what's best for our country. And on page 27 of the pamphlet that you'll see, it speaks a little bit before about total removal of the savings law clause, and that would address the matter of abortion. And the quote here says, our legislators have the duty to protect the most vulnerable. And then it goes on to suggest that abortion should be accessible by all. However,
for those who choose to do it,
coming
yes, go ahead.
from a place where in chattel slavery people were dehumanized because of their skin color, it seems quite contrary that we would repeat the same thing with someone based on their location. So logically, the only thing that two humans can reproduce is another human, right? And so discriminating against the developmental stage seems against all that we would want to do with the human rights. So I want to know how could it be justified for the Jamaicans for Justice, and if the panelists agree, how is this justified if we want human rights for all, both born and unborn?
Okay, so regarding JFJ's position, let me say again, it's speaking to the most vulnerable. But let me start to make it very clear. We believe in people's right to choose. So if someone chooses not to, that's your right being exercised. If you believe based on your unique circumstances that you would want to pursue an abortion, again, that is your right. But if one does not want to go to that level of liberal approach, what we're saying is that the Constitution should remove this special clause, and there should be provisions, for example, where the law expressly states that if there is a medical emergency, then an abortion can be done rather than relying on common law. So for example, in the United Kingdom, that our common law would be based on, I believe in 1860, they made their change. We're also saying that if a woman is raped, then that woman should have the right to undergo an abortion without being fearful that she can be imprisoned for life, or the doctor can also be imprisoned for life. So our conversation and proposal here at JFJ is speaking, one, around the vulnerability of those who choose to exercise their right based on their own circumstance, but certainly a doctor ought not to be fearful of carrying out a necessary medical procedure based on the gaps that exist in law. That's our position here at JFJ. Not sure if the panelists have any view there.
I want us to think a little bit about this in the context of slavery and the extreme violence that especially women experience in the context of their reproduction, control of their reproduction, and sexual violence. And if we think along those terms, the question of individual freedom to choose how to handle their body, I think, is something that our Constitution should provide for. One of the ways of looking at that is through a thing called maternal-fetal conflict, whereby some would argue that the fetus has, a kind of independent status of the mother. In maternal-fetal conflict, there is no consideration of the fact that the well-being of mother, the health of the woman, is important to the status of the fetus. And it was shown during the period of slavery where, for example, women who were pregnant, they would dig a hole, put her belly in it, and then whip her, as if she could not, experience the violence of it, or rather that, they were somehow protecting the fetus while disregarding the mother. If we take the perspective that mother's interest and her decision-making has some integrity, then we also have to take the position that the Constitution should both respect her decision-making and also give protections to her in that decision-making process.
All right. Thank you so much. That's it? Good.
I did want to clarify just quickly that what we should, in the Constitution, ensure that we facilitate is the protection of women, 100%, and the complete punishment of rapists. Because in any case, if a woman is raped and a 2-year-old was in front of her, the question of whether or not the person was a person wouldn't be in question. So it's not mother versus child. Both are humans, both have rights, and we need to protect and love both. Thank you.
All right. Thank you for your perspective, even if we disagree.
Akwaba, Xavier Yestelin. Greetings, everyone. I'm Haile Mikhail Kodjo, many things to many people, including being parliamentary caretaker for Westmoreland Eastern and author of this document, We the People Propose Constitution of Republic Jamaica, and the following poem entitled Good Governance that describes it briefly. We the People Propose Constitution of Republic Jamaica. It's a bloodless revolution that requires a mentally emancipated way of thinking. All it needs is parliamentary ratification for implementation. A mentally emancipated way of thinking is needed for it to be appreciated. Built upon foundations laid by the Lord Jesus Christ, Marcus Messiah Garvey, and Emperor Haile Selassie. It is designed to create a new and glorious history for ourselves and our posterity that shall increase our self-esteem, dignity, and integrity. We, the people holding the authority of the country's sovereignty, designated as one people under our eternal Father, God Almighty, we are guaranteed the Universal Declaration of Rights of Humanity. Education, therefore, is the key to unlock our potentiality, supported by defense, health, finance, foreign affairs, trade, and industry, social security, transport and works, and land equality. The Council of Ministers has the tools to work together in unity with those appointed and elected in their various capacity to ensure good governance is achieved and maintained in our beautiful country. Fixed election dates guarantees stability. Impeachment and removal of corrupt elected officials ensures accountability. Acknowledging our indigenous language frees us to express ourselves legally. No extradition, no death penalty, time limit between arrest and trial guaranteed to everybody. Full access to our beaches, waterways, forests, and natural resources. Our parliamentarians and hundreds of Jamaicans already have it for free. To get your copy, WhatsApp 1-876-225-1163. Then advocate for it to be the supreme law of our beautiful country.
All right, thank you so much. All right, we have to end with the panelists at 8 because that's the commitment made, so we have to move quickly ahead.
Thank you very much for having us.
Or rather.
Yes, the name is Ranger Latham. So I came with a certain mindset about this constitutional reform thing, and my scope has sort of broadened since coming here, and which brings me to a sort of a conclusion that this constitutional reform idea is really about self-preservation of those in Parliament at the moment. So, but few points have been raised about looking at other countries externally, especially with the CCJ, etc., and all that. So now, on the CCJ, my question would be, we're contemplating changing the monarch to presidential system, which are representational or executive or whatever you want to call it. Now, to go to CCJ as the final court, we're not with the West India Federation. So the CCJ, we're going to be, it'll be same as we're going to London instead of going to Trinidad. We're not a part of the broader Caribbean as a single political unit.
Keep the mic.
As a single political unit. Now, the other question that I have is the one I came here on, is to figure whether or not this parliament as it is constitutional. Reason for asking that is the September 3rd election. What I'm observing, or what I've read from the WHO Global Preparedness Board, something like that it's called, Global Preparedness Management Board, was a document they produced called World at Risk, in which it's pointed out in page 9 of it, I think, or page 10, bullet number 2, under subtitle, Progress Indicator by September 2020. The election was September 3rd, 2020. So therefore, I'm saying, if they kept the election on the 3rd, when they're instructed to queue a progress indicator for their, what we call a UN WHO training and simulation, what we went through was training and simulation exercise. Therefore, how can this parliament be a legal parliament? That's my question.
Okay, I heard West Indies Federation, and I'm not sure if the panelists captured to be able to respond sufficiently.
I think the answer, I understood the question,
Okay.
the latter question about the WHO and the COVID guidelines at the time.
Yes.
And there was concern at the time expressed about having the general election in September 2020, at a time when WHO effectively advised against it. That wouldn't affect the constitutionality of the parliament, of the election results. It may have been unwise, or one could question it as a policy issue, but as a legal issue, it's fine.
Okay, because I was getting something else, but all right, thank you so much. All right, go ahead.
Good afternoon. My name is Mohammed Abdullah. This whole concept of constitutional reform and the basic process that is now taking place is flawed. Flawed in the sense that our parliamentarians cannot find unity amongst themselves as it to relate to what they believe we as the Jamaican people want. The People's National Party selected representative. Jamaica Labour Party selected representative. And one of the most phenomenal things that I have heard coming out of this process is from Justice Usman, where he has said the whole process needs to be cancelled because it becomes politicalized. A man of his eminence had to go to the ministry to read the document. It was not given to him. And he's a part of the thing, you know, because of his own personal activity, he was unable to attend a few meetings. It is saying to us that the present person who is leading this whole process have their own agenda. And if you are going to change our constitution, why deny us the right to participate and reject from a democratic process? Because I hear everybody clamoring for the CCJ and as it relates to the Privy Council. But there's a present example as it relates to Vibes Cartel. Our legal system tried him. Our Court of Appeal tried him and did not identify. And while we had precedents of a prominent leader of this country, Michael Manley, where the jury tampering thing took place and nobody looked back to precedents. Mm-hmm. So how can we trust our own juries when that takes place? It's simple. And it's a simple law. When the jury's been tampered with, the judge tried. But they proceed to sentence the man. What would have happened to a poor man when I have money to pay a big lawyer? So these are some of the things where we have to look at. I don't really have a problem with CCJ or Privy Council. My problem is, can justice be guaranteed for all of us? in an economic way where we can afford it. Meaning that I can afford a lawyer to defend me, whether here or
Yes.
You understand me?
Let me ask, thank you. Let me ask one of the panelists to respond.
In the interest
Dr.
of
Payne?
time, you might want to take 3 comments. But I would say that, I think he is pointing out the same thing that Ms. Yvonne Sovers pointed out. There's a larger question of what is the structure of our society and whether it is just, and whether therefore the Constitution should not, or this debate around Constitution should not be thinking through how do we create a more just society.
All right. Thank you. All right.
So,
All right. A minute, Prof, and then we get to the young man.
very quickly, the issue of consensus amongst the parliamentarians is important. But that can't be the be-all and the end-all. One of the reasons why we are in this pickle now is that in 1962, you had consensus among the parliamentarians, but we the people were totally left out. So they set up a system which in many ways has shackled us. That can't be allowed again. So we need to make sure that we're not enticed. This is debate. We could change the monarch. Afterwards, we deal with all those other things that you're interested in, the policies that would help the people live their lives, women's rights. That's not acceptable. And we need to be very clear, using all the means at our disposal, social media, traditional media, to make it clear to the authorities, both publicly and privately, that public education, meaningful consultation must precede. The civil society organizations had proposed that would take at least a year to deal with some of these difficult issues that you guys are raising.
Yes.
And that is something that we need to insist on rather than be trapped into a referendum and then all things will come after that without any guarantee whatsoever.
All right. Thank you so much. No, we have to, just because of the time, we have just about 5 minutes left with the presenters.
My name is Nathaniel Muir. My question is, if Jamaica became a republic tomorrow, what would happen to the Constitution?
I think the Constitution has to be changed in order for Jamaica to become a republic. So that's what we are working on.
And we should use the opportunity to make other changes to make Jamaica better.
All right. Thank you so much, Mr. Muir. All right. Next.
Sure. Hi, my name is Jessica Lewis. I'm coming from more position on environmental sustainability. I'm interested in terms of framing human rights and how Jamaica can implement rights for the environment in terms of having rights of nature. A couple of countries have also implemented this, like Ecuador and Panama have given legal protection and rights to the environment and the species that encompass it, because in order for human rights to kind of live and...
All right, thank you. Just one response from one panelist. Who wants to take it?
Just a quick response. We had no rights to a healthy environment before 2011. The Charter of Rights gives us that right, but rights remain on paper unless they're enforced. And as we speak now, I believe there's a case before the courts, Mike, dealing with the issue of whether our right to a healthy and productive environment is not being violated by mining licenses that have been given and are now being challenged.
All right, thank you so much. The panelists who have to leave at 8, are you able to extend just another 5 minutes to those we have in the line? And we take a hard stop with the last person? All right, thank you. Go ahead.
Thank you very much, Clayton Moore. Good evening, everyone. Thank you very much, JFJ. I really appreciate this forum. I have a concern that I'd like the JFJ particularly to address. The whole matter of the selection of the non-executive president. Now, what I see from the position put forward by the JFJ, to me, is disenfranchising the Jamaican people. and we hear about, the participation of persons, and Dr. Them alluded to the whole matter of why we're not participating in the forum as a people. I think part of the reason when we do what the GFJ is suggesting in respect of making the selection of the non-executive president limited, even although you try to broaden it somewhat, houses of parliament, local government representatives, many Jamaicans, like myself, want to elect the prime minister and the president, right? Even if it's not an executive president. And so the concern is the position put forward by the JFJ disenfranchises the people on a whole. So perhaps, yes, we would need to have matters of recall, etc. But the position, I believe, disenfranchises the people.
Thank you so much for your view. And just to quickly clarify why we had that view and extended it a little bit, at the opening I mentioned that we want certain critical powers be given to the non-executive president. For example, before a law is passed, because right now the GG must sign on them and give assent. So we're saying that this non-executive president, if there is any cause for concern on a piece of legislation, they would then have the power to say to the Supreme Court, for example, please look at the constitutionality of it. So with those particular powers that this non-executive president would have, what we didn't want is that the political thrust of a direct election may undermine the trust among the public in this body. So what we proposed was to broaden the scope a little bit. Rather than having just the members of both houses electing, we would then extend it to the 228 councillors through a special electoral college. So we looked and we weighed. So we took your point when we were even having the discussion internally, but we believe that you have to be weighing the options to get a best outcome, which is why, on the other hand, we said that the Prime Minister should be directly elected by the people with some other safeguards. But we did consider the view, but I still take your point. All right, thank you so much. Next.
I have three very quick questions. One, why do we need a head of state and head of government? Why not have a directly elected prime minister, whatever you want to call him or her, and get rid of the other office in a country where people are hungry? That's one. Two, I am wondering, what next? Because you sense you have a society which is like a boiling pot with a cover on it. And yes, I like the forum, but what will we do? What's the next step in all of this to get to where we want to go? And sorry, my third question is things like the Integrity Commission, can they be written into the Constitution as well?
All right, very quickly, Dr. Thamar, Prof, I would ask one of you to take the question of why not merge to a single person assuming both head of state and head of government responsibility. Which one wants to take that one?
Usually they make a distinction in most constitutions between the head of government, who is going to be a representative not only of all the people but of a political party, whereas the head of state, by virtue of that position, is supposed to represent all the people in a non-partisan way. That's a usual rationale, but there's nothing sanctified about it.
All right, I will leave the other two questions to the end, just in case others may have a similar.
Okay, thank you. My name is Stephanie, and I'd like to ask Casey Hilton. He had mentioned that we should take action. I want to know what action can we take after we've stated our opinions and what we'd want as a nation. What action can we take to ensure that when they replace or remove the king, they also remove the crown's ownership of land so that it can be given to the people for reparations? What action can we take?
Thank you, Ms. Stephanie. The question of crown land is a much more difficult question than what I was addressing, which was enforcing rights that are given in the Constitution. So for example, gender-based rights and so on. The problem with crown land is technically it is not the people's land, it is owned by the government. It's called crown land, but it's owned by the government on behalf of the people. so that it's not a situation where one can say this is land that should be distributed because it is owned by the Crown. So the change to a republic, it would stop being called Crown land, but it would still be owned by the government. So it's not going to change that.
All right. Next.
Good night. Leo Bennett. 2 questions. One, our observation. It appears that the thrust for Republic is heading for a stalemate. What next? And what can we do as ordinary people to ensure that after so much scarce resource has been expended on this, it's just not just a talk shop, because the government hold firms on their position, and the opposition is holding firm on their position. What can we, the people, do to ensure that the republic become a reality? 2, how can the ordinary citizen challenge the powers that be? Prof talk about dictator. I have the firefighter who scaled the Arbitrary Transport Center. Up to today's date, there is no washing machine at the Yard Park Fire Station. A month after that enormous fire at the Riverton dump. We talk about the fundamental rights, the rights to life. Since the start of this year, serving members have been dropping dead. Stress. Mr. Stames, you spoke about leisure. We don't get a day off. How can we challenge Mr. QC? Mr. King's Counsel, how can we challenge the government in giving us a day off? Maybe the questions are too long for this time, but ponder on them.
So I'll ask Casey to answer the one about the challenging the time off, but I'm going to close out with the what next question.
Well, I would say that the Representative Association is challenging some issues, as far as I'm aware, with the government in terms of service. And that sounds like one that should be taken up. I don't know anything about the detail about it, but it is the kind of issue that should be taken up with the Public Service Commission.
All right, and just to answer one that was asked earlier, we are strongly advocating for the Integrity Commission to be entrenched in the Constitution. It was recommended in the 1990s for the Office of the Contractor General to have been entrenched, and we know that the Office of the Contractor General was merged and strengthened into now the Integrity Commission, and we believe that that recommendation should carry in 2024. You can't have that body policing not only parliamentarians but public officials, and the very people that they're expected to hold accountable can just go in Parliament and say, you know what, let me weaken the Integrity Commission by simple majority vote. So yes, we support the entrenchment. But I'm going to close out, or ask each panelist to close out, given the stalemate, what next and what citizens need to do to ensure that this republic, the road to republic, is reflective of their views and their vision for Jamaica. I'll start with KC and then close out with Prof.
Have more forums like this, have more public outreach and education, and have more voices heard. It is difficult to do it in the middle of an election process. A point Hugh Small has made. It is the kind of thing that will get done more easily post-election when that is not overhanging over our heads, and you have more outreach like this.
Okay, thank you. Dr. Fame?
And certainly based on the timing of, the provisions that once it's tabled, it has to sit in house for 3 months, etc., etc. I suspect that this matter will not be sorted before the next general election. And what it means is that it will be up to the citizens to continue to press on this issue, to self-organize, to self-educate, and to make demands, including through legal processes that are available to demand change.
Thank you so much, Dr. Thame. Prof?
I agree with what Maziki and Mike have said. More forums like this. But beyond that, we need to learn from our experience. When the government was intending to proceed to have a Chief Justice act indefinitely without any criteria in an unjust way, the various associations, the citizens, we spoke out and the Chief Justice had to be appointed within 1 month of being appointed to act. When the government was intending to keep secret cabinet papers, no longer for 30 years, but for 70 years, the Press Association, the Media Association, each of us in our various communities, we spoke out and the government had to withdraw the proposal. As we sit now, we need to insist that the budget for public education and the plan for public education, that this be disclosed to us and that the government accept its responsibility to lead and to be a partner in that public education process. Otherwise, we're just not in it. Simple as that.
Thank you so much to our panelists. And I will just close out by saying, an uninformed public is a politician's dream. I tell my students that every semester. So, in other words, let's not become the dream of any politician. And let us arm and equip ourselves with the knowledge necessary so that when we're voting in that referendum, we're doing it based on an informed position and not because we're supporting the position of any political party. We may not agree even with JFJ's recommendations, but the point is that even from a place of disagreement, let that disagreement be from an informed perspective and a principled and moral position that you have for yourself that is rooted in rights for all Jamaicans. Thank you so much to everyone for your time, your questions, and thank you to the team. And I must say special thanks to Nicholas, who has been on the ball ensuring that everything was put in place. And to the panelists, thank you so much. We really appreciate it. Have a good night, everyone.